We don't have to do that because what the judge cut out of this, because she's dishonest, is this key phrase, in the opinion of the secretary. Oh, that gives Kristi Noem the power, not courts, not hearings, not all the other things, with authority and discretion to decide whether the purposes of the parole has been served. Extremely dishonest. Thank you for calling her out. Why we can't have judges in his house, your house, John Roberts, who are violating that very balance of power. President Trump now back in the Supreme Court asking them to allow him to, be the president. He wants to eliminate temporary protected status for 500,000 illegals that Joe Biden brought into the country. He says, well, they're not actually illegal because we gave them temporary protected status. And we made this carve out in the law that allows our government to just funnel people in here hand over fist. Well, now D. John Sauer, the Solicitor General for the Trump DOJ, is going to the Supreme Court. The case involves Kristi Noem, Department of Homeland Security, and this one person called Svetlana Doe sued to say, you can't cancel our status. How dare you try to get control of your own country? This is ridiculous. We're in charge. So they submitted this application here from the DOJ, from Trump, up into the Supreme Court. And you can see this is fresh out of the oven, getting docketed May 8th, submitted to Justice Ketanji Brown Jackson, the very talkative Supreme Court justice, who is the most recent addition. And we've got a response due 1 week from today. So there was some action on it. And here's what D. John Sauer said. He wrote to them. He says, all right, listen, Supreme Court, I don't know how many times we got to be here. It'd be nice if you guys did something about this for once in your lives, but we're here. Now, what we're asking for is for you to correct a recent destabilizing trend in immigration cases that we've seen happen a lot. The Immigration and Nationality Act gives Kristi Noem broad discretion over a lot of things. Now, specifically, it allows her to grant parole to aliens on a case-by-case basis. Oh, you're under attack with your pupusa business? Okay, great. Urgent humanitarian reasons, or if there's a significant public benefit, she can grant parole. And it also permits, if she can grant it, then she can revoke it whenever the purposes of such parole shall, in the opinion of the Secretary of Homeland Security, been served. Now, the previous administration granted parole, that's Biden, categorically to aliens from Cuba, Haiti, Nicaragua, and Venezuela. Just said, oh no, you're all good. Oh, you're in danger. Whoa, what's happening? That led to 532,000 aliens in the United States. So you can't really call them illegals, really, because Joe Biden is illegal. Basically, he was an illegal president who just violated the spirit and the letter of the law and granted 500,000 people entry into our country. Now, on March 25th, then, Kristi Noem, Secretary Noem, came in. She revoked it. It was a categorical grant. He didn't do this on a case-by-case basis. It was unlawful for him to do that. So she revoked it. She did reserve the discretion to make case-by-case exceptions and would do that as needed. Now, the district court, nevertheless, held that the secretary lacked the authority to revoke the categorical grant of parole. So you can't do that. You can't go through this without an individualized case-by-case consideration for every single one of them, okay? Joe Biden didn't grant them access case-by-case. He just said, oh, come on in. Bring your fentanyl with you. Who cares? So he didn't do that. So why do we have to undo it that way? It then issued a de facto permanent injunction stopping Kristi Noem. In doing so, the lower level judge engaged in the very review that Congress said they cannot do. They upended critical immigration policies that are carefully calibrated to deter illegal entry. They vitiated core executive branch prerogatives, and they undid the democratically approved policies of our last election. Now, this court, you, Supreme Court, talking to you, Ketanji, should stay this lower level judge's order. Now, as a general matter, how this works normally, an alien who arrives in the United States and cannot demonstrate admissibility is either removed promptly or detained pending removal proceedings. You don't just generally get to run free in the country unless you're in the last administration where they don't care. Now, the law, the INA, it does say that in limited circumstances, the secretary, called Kristi Noem, may parole such an alien. That means release that person to allow them to be in the United States temporarily. But that parole authority is purely discretionary, okay? The secretary may, it says there, right there, quoting it, may, in italics, in her discretion, parole an alien applying for admission. It says in her or his discretion, and may terminate that parole when the purpose of the parole shall, in the opinion of the secretary, have been served, right? So the judge can't turn around and say, well, you already gave it to them, so now you can't take it away. Yes, we can. It's in the law. It says that. They wrote it down, and she has the sole discretion to do it. Now, the law clearly bars judicial review. Judges can't do this. It says in the law, notwithstanding any other provision of the law, no court shall have jurisdiction to review any other decision or action, the authority for which is specified under the law under Homeland Security. So what we saw is from 2022 and 2025, these treasonous monsters called Secretary Mayorkas granted 2-year terms of parole to 532,000 illegal aliens. I'm going to continue to call them illegal because what Mayorkas did was, I would say, illegal to the spirit of the law. From Cuba, Haiti, Nicaragua, and Venezuela. They called them special parole programs. He relied on categorical migration and country rationales. He said, well, if we encourage aliens from those countries to use parole, then it's going to deter surges at the border, right? That was their rationale. They said, well, if we just let them flood in and give them like temporary protection, then they won't flood in at the border. You're like, wait a minute, what? So you're going to prevent the leaking of the boat by poking another hole somewhere else? What? We got too many illegals coming in illegally at the border. Quick, let's bring them in illegally on an airplane. Dumbest thing you've ever heard. Why don't you just say, well, it's like doubling the pain, right? But they used it as a justification. Oh, we have to bring them in. Otherwise, they're going to come across at the border. Well, they are coming across at the border. So stop bringing them in this way. He was clear that parole could be summarily terminated. He even said that. His notices creating those programs, he wrote it. He said, the secretary retains the sole discretion to terminate this process at any point. So if Mayorkas can do it, so can Christie. Homeland may terminate parole in its discretion at any time. Well, Christie's doing that now. So reviewing the results of those mass parole programs, Trump concluded that they had best traded an unmanageable population of unlawful illegals at the southwest border for an additional complication by bringing them in. Neither place do they have a clear path to durable status. It's an invasion either way you do it. If you let them in, it's an invasion. If they come across illegally, it's an invasion. So stop it. In March 2025, Kristi Noem thus exercised her discretion to terminate the parole of aliens who had been granted parole under the CHNV programs, but reserve the authority to grant case-by-case exceptions. Now, in addition to observing that those parole programs had not accomplished their stated aims, the secretary emphasized that the programs had exacerbated backlogs or risked creating bigger backlogs for the entire immigration system, and they had major impacts, and they contravened Trump and the American people who just elected Trump and his immigration policy. She said there are significant gaps in the vetting process. There is massive fraud. We suspended certain portions of this as well, and our rescission should have been the end of the matter, okay? We have the discretion to do it. The fact that we did it should have ended the conversation. Congress specifically reserved those decisions exclusively to the secretary. She weighed factors and rendered her decision, and now you can't have some hack district court judge intervene. Instead, what she did is she certified a class of all aliens in the United States, all the people who got parole. She said, you all count. And though the INA, the law, expressly prohibits her from reviewing parole determinations, she did. She said that that bar was inapplicable. She said, well, I can look because the secretary can't use that law because she exceeded her authority. Now, even though the law gives Kristi Noem broad discretion to terminate, like it's in there for cost-cutting reasons or cross-cutting reasons, the judge insisted that terminating parole must be done on a case-by-case basis. It must go alien by alien, no matter that the programs that Christie terminated extended parole en masse, right? So they're saying once the right to stay, once that temporary status vests, then they're saying, oh, you've given them a due process right. So before you take that away, you got to jump through all these hoops. See how that works? So they can break into your house. They can steal everything of yours. If you want to kick them out, then you have to go and file a claim and prove it somewhere. They have no lawful basis to be here for 500,000 people, which is basically the entire state of Wyoming. So the First Circuit denied the government's motion to stay this. Trump said, you can't make us do this. We're not going to do that. The court refused to decide whether the termination of parole was immune to judicial review, just saying that, oh, they just kind of kicked it out, right? First Circuit, pathetic. Your immediate intervention is now warranted. The district court has nullified one of our most consequential immigration policy decisions. They have revoked Kristi Noem's decision to terminate parole for 532,000 aliens. Not only that, the court's rationale for disregarding Congress's clear bar saying you can't step in and interfere on this is saying we can. And if you allow this to happen, Supreme Court, it's going to enable wholesale evasion of all the laws, and they're going to do this wherever they want. Now, further, the district court's reasoning that parole revocations, oh, well, revocation is different. You can grant it to everyone, but if you're going to take it away, you got to do it individually. They say it contradicts the plain statute of the law, all right? It is a perverse one-way ratchet. Mayorkas granted parole categorically, just said, you all get it. But the court faulted only Kristi Noem's decision to restore the traditional case-by-case process by undoing the prior categorical grant. But the law prescribes the exact opposite, okay? okay, it says literally that you can grant parole only on a case-by-case basis, right? So in other words, Mayorkas broke the law. They're quoting it. It's here, 8 U.S. Code 1182 2D5A. The secretary may grant parole only on a case-by-case basis for urgent humanitarian reasons or significant public benefit. There is no benefit. But the secretary may terminate parole whenever, in her opinion, the purposes of such parole have been served. Okay, it's done. Like, in other words, the hurricane's over. Go home. Your emergency's over. Your pupusa attacks are over. See you back home. But Mayorkas inverted that, and the judge is trying to do the same. In any event, agencies routinely make case-by-case determinations by applying uniform criteria to all individuals. And that's what the secretary did here. And the judge at the lower court, and her indefinite halt of this revocation irreparably harms the government, all right? The court's order blocks the executive branch from exercising its discretionary authority over a key aspect of immigration policy and foreign policy, and it thwarts Congress's express vesting of that decision to Kristi Noem and not to the judges. And further, Trump, the government, and America has a strong interest in expeditiously removing aliens who lack a lawful basis to be here. But the order stymies our efforts by requiring individualized parole determinations for every one of the 532,000 parolees, which of course would be a colossal undertaking. That's the point. If it's so big and colossal, they're not going to be able to do it. If Homeland cannot terminate parole until the 2-year period is up, Homeland also faces the prospect of foregoing expedited removal and undergoing full-bore removal proceedings for each alien, which would tax an already overburdened immigration system, right? This is the point. They want the systems to break. And if the systems break, then the courts can't process anybody, and then everybody stays. Finally, delaying the termination risks undermining the government's ability to conduct foreign policy. We got time-sensitive negotiations and more. But on the other side of the ledger, these illegals, the respondents cannot claim any cognizable harm, okay? They accepted their parole status with full awareness this was temporary and revocable at any time. And so the Supreme Court should put an end to this recent and destabilizing trend in these immigration cases and stay this judge's decision in full. And here's more background on this, saying in late 2022 and early 2023, Homeland created a special program, right? That was all Mayorkas and some of the worst people ever to be in charge. For each program, Homeland cited categorical reasons, right? General migration, that's all. We're going to reduce irregular migration by invading them in and eliminate the burden on criminal smuggling networks and all of those things. And so they granted an onslaught. Then Trump came in, boom, January 20th, executive order, said not anymore. Issued an executive order reversing all of it. Homeland came out, issued their order. She published a notice in the Federal Registrar and said, we're ending this. We retain our discretion to commence enforcement. You've got notice, and now you know. The secretary acknowledged that the reliance interest of parolees and potential future program beneficiaries and more, right? So she considered everything. So don't act like she was just acting with haste. She found those individuals knew that parole was discretionary and that the programs could be terminated at any time. And it was in America's interest to do it. So she did it. So then what happened is 23 people sued. They said, you can't do this. We have rights. The district court then entered a class-wide stay, right? All of you non-citizens now suddenly get process rights. You have a class. She said that they're going to win under the APA, which is ridiculous. She said that one of the secretary's justifications for terminating the parole was on a legal error. And second, she said that because parole may be granted only on a case-by-case basis, termination of parole must also be individualized. But that's not what the statute says. She found that respondents would be irreparably harmed if you terminate them early. They would have to leave the country on their own, or they would have to await removal proceedings, and said, you guys can wait. So you can just wait 2 years and they can stay and do whatever they want because they're better than you. I mean, you're an American, maybe watching the show, or some other foreign citizen, of course, but American citizens, we voted. We elected a president and a Congress to make these changes. We don't want to wait 2 years. That's why we elected people now. So she just, well, you can wait, and the illegals have more rights than you do. Okay, so we made the decision. Their status is revoked. We don't have general migration problems. Border's fine, by the way. Border as secure as can be. We didn't need any stupid bill from Senator Langford from Oklahoma. We got it figured out. Thank you, Tom Homan and Trump. So now, since we don't need to invade them via airplane and Uber illegals, they're not going to come across the southern border. So the basis of the whole program is moot. It's canceled. We don't need it anymore. But you have to keep it because they're more privileged than you. You don't even control your country anymore. This judge and the non-citizens do. The First Circuit denied a stay. Now, Trump says, totally ridiculous. You incorrectly asserted jurisdiction. First of all, Judge, you have no power to even look at Kristi Noem's decisions. You cannot adopt a narrow reading of the bar to your jurisdiction. It says, literally, Judge, like, can you read? It says, no court shall have jurisdiction to review this. It's very clear. Now, neither the respondents nor this judge disputed that the law reserves parole termination to the secretary's discretion. Nobody's disputing that because they can't. Other courts agree, and they've held that these discretionary revocations are literally unreviewable. You can't even look at it, citing cases. But the district court ignored it, sidestepped the rules and the plain text and said, I do have jurisdiction because the statute cannot be read to give the secretary this discretion to terminate parole because it's individual. It needs to be individual. Now, that is doubly wrong. First, it doesn't forbid categorical terminations. We already explained that. And even if it did, it still precludes judicial review. Again, that provision bars judicial review when the authority for that action is in the secretary's discretion. If she can do it, then she can do it. That provision thus focuses on whether the statute provision grants discretion over particular decisions, not the manner in which she exercises those decisions. Here, the law plainly says Kristi Noem has the authority to revoke parole. That's what she did. And she can base it on her opinion. Now, that is about as a discretionary of a grant as you can get. Even if she were to exercise that discretion improperly, Congress specified that the authority to revoke is within her discretion. So you can't say you have jurisdiction because you're literally barred under the law. Now, they tell the Supreme Court her reasoning to the contrary would nullify what is in the statute. That bar would apply only where a court first determines that she acted lawfully, not where she thinks they violated the INA. But the bar is supposed to foreclose review of actions within her discretion, not induce courts to review the lawfulness of those actions to decide when it's foreclosed. The courts below ignored this fundamental point. They suggested instead that the jurisdictional bar might not apply because they allegedly challenged the legality of policies and processes governing discretionary decisions under the INA. What? But there is no overarching policy or process separate or distinct from that. So in other words, it's like they're challenging Trump's interpretation of the law or the policy surrounding the law rather than challenging the law. Because if they challenge the law, they're going to lose. The law says she can do this. It's right there. It's in writing. So they can't sue to challenge that. So they got to challenge this other thing. It's like the legality of the policies and the processes. What? Okay. Well, she has discretionary decisions, but the decisions are impacted by the policies. And so we're challenging those because you can't challenge the discretionary decision. So it's very convoluted. They write to the SCOTUS. They say, but there is no overarching policy or process that is separate from this. The secretary acted to end the parole programs entirely, not to promulgate some other policies or procedures. She's doing what the law says. She's using U.S. code to terminate it, not some other decision. It's all based right there in the law. But the district court relied on a presumption of judicial review, saying, I presume that I can look at this, right? Courts generally want to look at things. When you tell judges you can't look at that, they generally don't take kindly to that. Here, Congress clearly and convincingly directed that no court shall have jurisdiction to review. So it says it, Judge, like, I'm sorry, but it's in there. And that jurisdictional bar applies to you. Where parole determinations are concerned, nothing in the relevant immigration statutes at issue here suggests that Congress wanted the court to improperly second guess the president's Article 2 judgment with respect to American foreign policy and foreign relations. Judge Kavanaugh wrote that in 2022. All the evidence points the other way, which means against review, meaning this judge can't substitute her opinion for Kristi Noem's. Now, separately, they are suing under the APA, the Administrative Procedure Act, which is like their catch-all. But the secretary's termination is also unreviewable under that. The APA does not authorize judicial review when agency action is committed to agency discretion, right? If the agency lawfully has the discretion to make that decision, you can't sue them for that. Or when the statutes preclude judicial review, like it does here. Now, this is a statute that says the courts can't look at it, so you can't look at it, and you can't sue under the APA because the APA says you can't. Now, the district court instead reasoned that a decision to categorically terminate parole is not within her discretion, right? Saying, well, the law says you can't categorically do it. And so therefore, I don't have to follow. Therefore, I can review you because the law says you can't do that thing. But that simply repeats the court's mistaken view that you have to do terminations on a case-by-case basis. You can. The lower level mistaken judge said that the law establishes standards for termination of parole, which would mean on a case-by-case basis in her interpretation. But the court's ellipsis elided the key phrase in the statute. Okay, so you see what this little sneaky judge did? You know, like these judges, man, supposed to be honest and full of integrity and all this crap. Judge, you're just getting called out, man. This is good lawyering by the Trump DOJ. The judge wrote this, right? See this little ellipsis here, these three She left out a key part of this. She says, well, the law, quote, here's what the law says, establishes standards for termination of parole by requiring a determination by the secretary that the purposes of the parole, have been served. So the judge is going to insert due process in here or something. Like you have to go case by case. You have to give notice. What does she want a case by case analysis for? Because that's a hearing. Got to look at it. Somebody's got to sign a box. They got to get notice that you're making this decision. Then they got an opportunity to be heard, to challenge it. That's a hearing. Case by case basis. That's all it means. But we don't have to do that because what the judge cut out of this, because she's dishonest, is this key phrase. In the opinion of the secretary. Oh, that gives Kristi Noem the power, not courts, not hearings, not all the other things, with authority and discretion to decide whether the purposes of the parole has been served. Extremely dishonest. Thank you for calling her out. There are no judicially manageable standards for courts to review, okay? It is the secretary's opinion. The U.S. Code says so. Wow. Now, the district court's reliance, this dishonest judge, so I can rely on this case, that's misplaced. That case involved what the court called a program for conferring affirmative immigration relief. And here, the government has never argued that these parole programs are non-enforcement policies. Judicial review is barred because it says so in the law. Now, even if the secretary's decision were reviewable, the government is still going to win because the district court misread the parole and the expedited removal statutes. Indeed, the court's reading produces an extraordinarily perverse result. Though the previous administration granted parole on a categorical basis under Mayorkas to over 500,000 aliens, non-citizens, this administration cannot revoke parole unless we do it individually, case by case. Now, to start, the district court made a mistake. They erred in concluding that the statute imposes a case-by-case basis requirement. The statute explicitly says the opposite. It literally requires case-by-case determinations for granting parole, providing the secretary with certain exceptions. In her discretion, parole into the United States may prescribe only on a case-by-case basis for urgent humanitarian reasons or significant public benefit, all right? But the removal contains no parallel language with respect to termination. It doesn't say that at all. It says only that when the purposes of such parole shall, in the opinion of the secretary, have been served, then the alien shall be returned to the custody from which he was paroled. Back out, right? It's like the exact opposite. The court inverted it. Congress's inclusion of a case-by-case limitation when granting it, but not terminations, shows you it doesn't need to be individualized. Like they know what a case-by-case individualized basis is. They put it in the incoming, but not on the outgoing. Saying where Congress includes particular language, you should say that they mean what they said. For good reason. Many conceivable grounds exist for terminating parole may apply to more than just one parolee. For instance, let's think about it. How about a change in geopolitical conditions? That might eliminate the urgent humanitarian reasons. Oh yeah, their pupusas are all fine now. Thank you, Nayib Bukele. Go home. Or the secretary may determine that all aliens paroled solely because of a shortage should be redetained once the new detention facility becomes available. Now here, one independently sufficient ground for terminating parole is that those programs granted parole to hundreds of thousands of aliens without any case-by-case determination. Like that alone, requiring the secretary to make a case-by-case determination to terminate was granted on a categorical basis. That would overburden the system by design, obviously. But the lower level judge, she says that you have to do this individually, but the reasoning lacks merit, and it proves too much. Countless provisions, not to mention the statutes, use the singular rather than the plural, and you can even read the dictionary definitions about how all this works. Case-by-case basis is incoming, but regardless, the INA, even if they impose some sort of a case-by-case basis during terminations, that wouldn't stop Secretary from establishing generally applicable criteria that she could apply to everybody. Even when Congress does require individual determinations, it doesn't displace their authority to make these decisions, which is what they're saying this is. Long-standing regulations take that approach, and this court and others have repeatedly said that generally applicable determinations are appropriate in the immigration context. And this was not arbitrary and capricious either. So D. John Sauer writes to the Supreme Court saying, the district court also made a mistake in concluding that Kristi Noem acted arbitrarily. She called it, the lower level judge, obvious legal error. What? One of the reasons Kristi Noem gave for terminating this parole in 30 days rather than 2 years is because we don't want him here for 2 years and we don't want long drawn out removal proceedings. But this court concluded that they're not subject to expedited removal and that's not available. And the court interpreted that language to mean that any alien who's ever been paroled is categorically immune from expedited removal. But that's not correct. Saying an alien whose parole has been terminated, in other words, we can get rid of these people pretty quickly. And her rationale for doing so is legitimate. But if you think she made a mistake in that rationale, that error doesn't justify halting the parole terminations because she's got other bases for this. And the humanitarian basis has also been vacated. Even the district court acknowledged that her decision rested on many factors. So if you don't like one, she's got 5 more, but she improperly dismissed all of those other reasons. And so the Supreme Court, you should grant this and accept our claim. We're going to win. There is irreparable harm that is happening on the people. The president is a representative of the people, and we have a substantial interest in having our policies carried out. These concerns escalate where some judge issues an injunction that undermines the executive branch and interferes with America. So by disregarding a congressional law that tells this judge, you cannot do this, she encroached on Congress as well, right? So she's saying, I don't care what Congress says I can do. I'm going to do it anyways. I don't care what Trump says I can do. I'm going to do it anyways. I'm the president now. The irreparable harm here is acute. The lower level judge's order stymies the government's ability to terminate parole grants that the secretary has determined undermine U.S. interests, and it inhibits the government's pursuit of its foreign policy goals. And the court entirely discounted those harms on the grounds that it is not in the public interest to summarily declare 500,000 people no longer lawful. Well, it's going to be a big problem. It's like 500,000. Yeah, we know. Neither ground has merit. It's not your decision, right? This is the judge saying, wow, that's going to be a big problem if we do that. Well, that's not your decision to make. Christy No made that decision. We know what's going to happen. Neither ground is sufficient. Now, the Constitution and the INA grant the secretary and the political branches of the court the task of deciding whether it's in the public interest to allow 532,000 aliens who were never admitted into this country, who were paroled en masse, who have not been inspected to remain in the country. She says it's a big deal if we say you all got to go. We say it's a big deal if you all stay. She says my decision is better than yours. We say you're a judge. You don't get to substitute your judgment for ours. As to the second, Christy Noem explained at length in her assessment that our foreign policy approach is more consistent with this decision. She explained that any delay in terminating these programs would undermine the ability to conduct foreign policy with foreign nations, saying U.S. policy has changed in critical respects with regard to these. We're no longer taking everybody's people in context of time-sensitive and high-stakes negotiations. Now, on top of all of that, the lower-level judge also improperly encroaches on one of the executive branch's key functions, which is managing the immigration system. The order contravenes the government and the public's, strong interest in quickly removing aliens who don't have a lawful basis in our country. The order also effectively compels Homeland to place a greater proportion of this population in removal proceedings to effectuate their removal, which is going to overburden the system even more. Now, she's ignoring a prohibition on her judicial power and stiffing it to Congress too. She attempted to minimize those harms by observing that the order does not itself authorize the entry of the aliens. Well, I'm not like giving them lawful status here. You kind of are, but we extensively considered their alliance interests. Like we know what's going to happen when they're all revoked. They're not going to be happy. There's going to be all sorts. It's going to be, not happy, but we know making individualized determinations for 532,000 people would be enormously burdensome. It's tantamount to permanently enjoining any termination of the programs. Okay. So in other words, like there's no way you're going to do 532,000 trials. It's effectively hamstringing the whole thing. Now, on the flip side, this would not harm them. All of them are on parole. It's discretionary. They all knew it. They all knew it could be revoked at any time. Mayorkas repeatedly admonished them, said, we can terminate this at any time. And we might. Some class members may have already obtained immigrant or non-immigrant status and would thus suffer no meaningful harm. Like if they've already worked through the system, they're fine. But the termination of parole is not equivalent to a final removal order. They can still seek asylum. They can still assert their claims and more. But when lower courts, Supreme Court, have disregarded Congress's commands under the law, violating Congress's rights, and usurp the executive branch's power, violating the executive and Trump's rights and our rights, this court has not hesitated to intervene and repeatedly granted complete or partial stays of nationwide orders. And they cite them here. Did one there, did one here, did one over here. And you should do the same now. Writing to the Supreme Court of the United States, D. John Sauer, saying this court should stay the district court's order. Respectfully submitted into SCOTUS. So sending in, it looks like a copy of the judge's final order here, which sounds like it's just horrible. The law is, funny because you can really find a path to whatever you want. And if you're a political partisan hack who just takes an oath and swears to uphold the Constitution and you don't really mean it because you got your fingers crossed behind your back and whatever, Constitution, then you can do whatever you want, as this judge has done. But we're hopeful the Supreme Court comes in here and settles this down. Now, our friend Jack Posobiec had a clip here of John Roberts, the Chief Justice, when he was seated having a conversation clipped over from CNN. Here's what John Roberts was saying out hitting the media.
In our Constitution, judges and the judiciary is a co-equal branch of government, separate. There's with the authority to interpret the Constitution as law. law, strike down obviously acts of Congress or acts of the president. And that innovation doesn't work if the judiciary is not independent. Its job is to obviously decide cases, but in the course of that, check the excesses of Congress or of the executive, and that does require a degree of independence.
Yeah, it does require a degree of independence. It's true. We do have 3 separate but co-equal branches of government, pretty basic, similar to how the executive is independent and deserves its independence, and how Congress is independent and deserves its independence, which is why all of these pseudo agencies that kind of live independently of Congress, live independently of the executive branch, and nobody has real control over, why all of those are unconstitutional. And a lot of what we've seen happen in these injunctions have emanated from cases just like that, saying, you can't fire me. I'm at the Merit Service Protection Board. Like, the hell, where do you live? I'm independent. No, you're not. And a lot of these decisions were made by these agencies, and policies and different interpretations of the law have been perverted. And the executive branch is now clawing that power back. And we're hopeful that John Roberts, if he's going to come out here and tell us an independent judiciary, hopefully he understands that the reason the judiciary needs to be independent is the same reason the executive branch needs to be independent. Same reason why we can't have judges in his house, your house, John Roberts, who are violating that very balance of power by stepping in and not just saying what the law is and striking down something unconstitutional, but making judgment substitutions by saying, well, if we revoke 500,000 people, that's going to be a problem for the country. No one cares what your opinion is, Judge. You didn't get elected. No one knows what your policy positions are. If you want to run for president, you can run and do that. The law says Noem has the discretion to do it. She's doing it, her discretion. You might disagree with that discretion. That's not your power, so it's illegal. John Roberts can come in and correct this. I hope he does very soon, because we're getting tired of getting lectures about independent judiciary, getting mad about Trump, talking garbage about the judiciary. You guys can have your independence if you honor the independence of the other branches and you stop stealing their powers. Then we'll show some due respect to you. Otherwise, we're going to continue to call out your lying hack judges that you allow to fester, who are political appointees of the Democratic Party, undermining the American people. We're tired of it, John. Do something!